So we have not yet faced this topic, right? So we have started the type of companies. So now we know that there are different type of companies that we can incorporate and recognize under the Companies Act. So basically, yes, we have discussed three types of companies can be incorporated as limited companies, unlimited companies, and companies limited by guarantee. Just give me some comparison about limited companies and unlimited companies. Just to recap what we have done last week. What are the differences between limited companies and unlimited companies? Unlimited companies, you all know, it's not popular in Sri Lanka. There are many unlimited companies, for instance, right? However, the Act recognizes a type of company as an unlimited company. So, what is an unlimited company? Even though they are underutilized, you still can use them, right? You can incorporate a company as an unlimited company. What is a limited company? What's the main difference between these two companies, limited companies and unlimited companies? Difference between limited companies and unlimited companies. Okay. Customer, you need to clearly know what is an unlimited company. Unlimited company, there must be at least one shareholder. They are liabilities not limited to the shares they have bought. There may be some shareholders, their liabilities may be limited. But there will be some shareholders, their liabilities not limited to the shares they have. So therefore, they are liability of members of unlimited company may be very similar to liability of a sole proprietor or partnership. So that's the main difference. However, sometimes we need companies or business without limiting their liability. A good example is the professional firm. The public people don't want to have their consultant as a limited liability company. Therefore, those professional firms and consulting firms can be incorporated as an unlimited company. And also, the reason to incorporate a company is to buy a land or something. You don't need to bother whether it's a limited or unlimited company, right? Because the reason is to have a cooperative to buy some lands on the company's name. Right. Then what's the difference between limited companies and guarantee companies? Difference between limited companies and guarantee companies. Yes, okay, Pataka. There are a lot of differences between guarantee limited and limited by guarantee and limited by shares. Mobile phone, mobile, laptop, mobile, or camera. And we are going hard. Online students, you can also join us. You can, yes. Explain us the difference between limited companies and companies limited by guarantee and companies limited by shares. Okay, you start. Limited companies owned by. Yes. Until we get yes next. You all listen now, right? Okay. I think you take to the class, not to the video, okay?
Limited companies usually form to pay properly. Current limited companies usually form to non-profit purposes like charity.
Okay. It's a practical application of the objective of having the company and limited company. Okay. But it is not a law, it's not a strict law, but it's okay. Okay. Next.
Guaranteed limited companies of like members. Guaranteed
Right. So, did you hear that? No? I haven't done. Yes. Didn't part, they come for never.
The liability companies on the shareholders. Guaranteed limited companies owned by members. Contribute each amount.
Right? Is it clear?
Yeah.
Then if I say companies owned by limited companies owned by members, is that wrong? Or if I say companies belong to the members, is that wrong? Is there a difference between member and shareholder? Yes. What is the difference? You are a member of you are a shareholder of a company. If I say you are a member of that company, is that wrong? कुछ doubt नहीं करेगा get to assure नहीं मालूम होगा नहीं but he said this correct, but you need to understand what is it. Right. It is like this, right? So in Sri Lanka, guarantee companies do not issue shares. If you don't issue shares, obviously there are no shareholders. Right? So therefore, in those companies, the owners are known as the members. Companies which issue shares. Those members, shareholders, or members, there's no difference. Both are same. For the company with issue shares, there's no difference between the term member and shareholder. But for a company which does not issue shares like a company, you can't use the term shareholder because they don't issue shares. So therefore, they are termed as members. Therefore, in a company, index register, so the share register must be replaced with the members register. Right? Shareholder must be replaced with the member. Right? When you calculating, you have to calculate each member has a one share. Right? Other shareholders. You can member here. If it is a company issue, there's no difference between the term member and shareholder. Right. Happy company shareholder was used to back. Happy company members meeting here. Whether it is shareholders meeting or members meeting, almost same. Right? Well, something on it. It's clear. Okay. Well, you come here, right?
Immediate liability company. So basically to earn profit. Immediate guarantee company mainly for non-profit or charitable outsourcing.
Okay. Thanks. That you want? Right, okay, yes. In the, yes, when you do accounting and all, yes, basically, guarantee company, you don't have a loss and profit account, instead you use the term income and expenditure account. Okay, when you do audit of club and all, so you have to do this thing. Club holder or club holder, take club holder, you know, loss and profit account here, what? Yeah, so income and expenditure account here, so I have a okay.
The companies that have share capital. Companies have share capital.
Right. Yes, they don't have a don't issue share that no share capital. Instead, they have a you have a, you know, the amount they have agreed to pay. That's okay. They have to get what the again. Article so they acknowledge the amount each member has agreed to pay at the rate of 0.8. Yes.
Indian company pays dividend to shareholders. Yeah, the company got distributed to the board.
Right, yes. Can company cannot pay that, dividends as compared to have shares for them.
And companies are managed by all of them. And I think your friends are managed by your friend.
No, it is correct. These days, limited companies are managed by the board of directors. Guarantee companies are managed by the members. Where did you get that source? Where did source get that? Yes, I will agree with you. Huh? My members are the company managed company. Even the guarantee company, they must be, you can't incorporate the guarantee company without directors. Right? You cannot even incorporate the company without the director. Right? Form 18 network company and incorporate the company. So it's a company, they have to be managed by the board of directors. Whether it's a guarantee company, unlimited company, no limit company, whatever, they must be strong, right? So in this also, it is a wrong information, right? But members involved in the management, even in the division company, right? To some extent they involved. But the big companies are run by the board of directors. So did you mean that there are no directors in the guarantee company? There are directors, you cannot even incorporate a guarantee company without the director, right? There must be a director. Okay. Next.
Limited companies has share capital, has guarantee companies. It's not kind of share capital. If the companies have shareholders liabilities similar to the amount of their share. Guarantee company, members liabilities similar to the amount they guarantee to pay.
Is it fair what he said? They are giving amount to pay. It's okay. What is this? Are you clear what you said? So in the limited company, members liability is limited to the. It is limited to the share they have bought. Right? If they have not fully paid, then they are liable to pay on cost. Right? They can give it a given, but they can give it a given. If it is fully paid, there's no liability. Right? The gap is limited. So their liability is limited to the amount they have agreed to pay at the event of buying it up. Okay. Next.
They can raise capital through shares, but donations.
It is contributed by the personal vendors are contributed.
They said somebody.
Can you hear? Again on again.
If their company can pay expensive shareholders. Currently, company operates on that you company have to pay the.
Is it clear? केवल आकर या केवल पहले it is not 100% correct, but in some guarantee companies, they cannot use the profit. They cannot share the profit in some guarantee companies, not all guarantee companies, especially in association, not for profit. Members cannot share the profit by way of dividend or otherwise. But in limited companies, they can share the profit by way of dividend or even bonus share or whatever. Some other guarantee companies they have that. Right. Okay. Right, Ilan? What companies?
Immediate companies by the example that they are private dividend public.
Can you repeat it slowly, please? Okay.
Common example as private dividend, public dividend. Charities and donations.
Right, right.
SPV.
They give some example for the limited companies and the guarantee limited. Okay. Right. Yes. But the Tawas, we have come in one that never said we must help you. Yes.
What is that? The company pay from share pay of company one pay the companies are common businesses as well. Companies are common social.
Right, okay.
Can issuing shares, but the companies can issue shares on the relevant donations, grants, membership fees.
Okay. It's by selling gas.
Skeleton. Skeleton. If I don't get it. Very good.
Shareholders liabilities limited to share capital. Guarantee company super liabilities limited to the guaranteed amount.
Share can be modified shares.
Can we? They can't hear you. It is almost all of it is on the top. What did you say? Oh, I mean,
The company's profits are distributed to shareholders as dividend. And the company's profits are not distributed. No structural organizations also.
What they can do, you have to make something unique, something funny, something interesting, something memorable. Then, when you are given the opportunity in the class, make it nice, make it interesting, make it important. Right?
Companies
If you have a fast one, you class to do not, it's not going to go on again. Right? The Viran Park here, the Park passes.
attractive to behavior. Currently, companies not attractive.
Okay, right. मैं रहेंगे वगैरह I think he's very slick. Because I remember in Hong Kong, you know, again from there, I left him for this. That's the important reason I need to know it. I fully aware of that. Because master tax cost tax concession again recompense, right? Are you aware of that, or you just told to begin? If they don't, yes. So when that was my company, the was advantage. Right? So you don't need to pay tax as you do in the limited company. Therefore, there are some private universities, they try to convert their business as a grant limited, then they have to pay very less taxes. Right? See, grant limited, they are from. So they will should have tax like CSC. What is that? On the limited companies, would have a tax. What? What about that? You have to. Yes. Right, so apart from that, so CSP got the thing, CSP limited. Right. Apart from that, there are some other differences. Say, as an example, to incorporate a limited company, you can incorporate a limited company even with a single member. To incorporate a guarantee limited, you need to have two members. Minimum members to incorporate a guarantee limited is 2. Minimum members to incorporate a limited company is 1. Right? In a limited company, it is the object clause is optional. But in a guarantee company, there must be an object clause. Right? So in limited companies, shareholders are liable to pay on calls. In a guarantee limited, members are only liable to pay at the event of winding up. Is there one? Division company dividend by interest. Liable to pay on call. Right? The guarantee company handle that. They are only liable to pay at the event of finding. Well, I don't limited company can differ bank approach again. So those are some other differences, right? Limited company may be either private limited or public limited. Gas limited may be either gas limited or association not so. Right? So I think differences still about we can talk about what you know again. But it can't get to the moving on. Right? Then likewise, you also can prepare private limited and public limited. Make guarantee limited and association not for profit. Right? Like, so lastly, we have also discussed offshore companies and overseas companies. As I remember, I asked you to discuss some advantage and disadvantage of the country and those companies, and simply why we promote offshore companies and foreign companies to register in Sri Lanka, and why those people come to Sri Lanka. Right? One would discuss that. So offshore company is a company which is incorporated here in Sri Lanka, but they cannot do business here in Sri Lanka. Right? So foreign company is a company which is already incorporated in other countries, but if they want to do business here in Sri Lanka, then they have to re-register as a foreign company or system. So why do you think that they are important for us? Why we encourage them? Then Dubai, Malaysia, Singapore, haven't been so far and make you a company. What are the advantages as a country? Appeal Mokadati advantage gave up one. Yes, one thing is foreign currency. Right? Foreign currency is the one main reason to promote such a company because they have to pay registration fee. Unlike other companies, they have to re-register every year. Right? And also registration corporation fees are also higher than the division companies. And therefore, in that we can take some foreign currency. Right? Okay, that's one advantage for our countries, right? One place. Well, Jumbo duties, right? Sometimes overseas companies can do business here, but still they can have business place. Foreign company, they can do business here. Therefore, that definitely will provide the job opportunities. Okay. But yes. I'm not the last ever. Taxes here, sometimes more taxes for foreigners, doing business, right? So tax revenue, that's okay. Export opportunities, okay. Yes. But yes. New technology, I mean, those companies, they want those our traditional things make. So therefore, you also have to explore the new technology, right? But yes, foreign investment, right? Then in the GTT, SLP, SLP, okay, generally BTT. The kind number that I was going to the Lanka, and India. Computer, India, like over there, Iraq, Roti, is like money. From India, like me, because you know, London was the current common. Like what days? Yeah, even we can see all like infrastructure development, maybe banking finance, even the road them are turning. Then we manage, you know, but the building. It is made by things. Now it's a public road, right? Private. They can public road there without it, right? So you can say again infrastructure of it, right? Like what else? Local companies? Yes, they also can partner with them, right? It's some, so those are some advantages for the country. Right? And also there are some indirect advantages like tourism. Right? Lanka වගේ Thai ඒවා තමයි. ඒ කියන්නේ අපේ කන්නේ කන්නේ තමයි. Right? මේ honestly yes. අපිට again this is very very popular as a beautiful destination. Right? ගොඩක් යාළුවෝ ලංකාවට ආවම ඒවල family වල එකක් කියනවා relations අතෙන්ද කියනවානේ. ඒ වගේ මේ indirect advantage that tourism promote right? So likewise, so there are those are the advantage for the country promoting overseas companies and overseas companies. I think overseas companies, foreign companies are now also permitted to list as. So did all those countries come to Sri Lanka to give all those advantage to us? Everything must be two-way, ne? The fact that 50-50 හරියන්නේ even stock monopoly. What advantages they enjoy? Regular monopoly advantages. Mainly අපේ වගේ අතවල මොනවද තියෙන්නේ ඒගොල්ලන්? Mainly මේගොල්ලන් තියෙන එක තමයි cheap labor, cheap land, නේ? ඔය දෙක ගොඩාක් වෙලා තියෙන්නේ. Better living, right? On the guy, we have to be each German returning. England, the body is here, get the mother to come. If I get a thousand might take a packet of follow-up. Where the hack they will probably see upon a key, probably see upon a passing area. So it does a night shift track in England. India is among Sati and market facilities. ඒගොල්ලන් දෙක තමයි ඒගොල්ලන් තියෙන වාසිය cheap labor. It was cheap lands. So ඒවා තමයි mainly ඒගොල්ලන් තියෙන්නේ available නේ. Maybe some tax benefit in the some other thing. So those are the reasons for them to come and invest their business. Yeah, that's extreme like that. Someone ඒගොල්ලෝ Lanka and there and Lanka cheap. Bangladesh army here and I have issues with the made at all case. So what is it? Those are the main reasons for them to come to countries like Sri Lanka. Cheap labor, cheap lands, and the flexible laws, tax benefits. Right. Laws they don't have an issue against someone Lanka with them with. Because our laborers are very complicated. So therefore those people don't want to come. So that's very strict. And our laborers are more friendly for the laborers, employees than the employers. Egoland are clear, strict laws for them. Lanka, I think Egoland recent cut the Lanka way at all. Right. So apart from that, Act also recognized the holding companies and subsidiaries. Right. So what is a subsidiary company? What is a holding company? It is given by interpretation section 529. Maybe tell me interpretation section how company become a subsidiary of another case. Well, subsidiary you can refer the section 529 interpretation section. So what basically you know what is the subsidiary company? This is what not only the experts, the majority believe this is what the subsidiary company. If A company holds more than 51% of shares of B company, then B is a subsidiary of A. Over the have a legal according to section 529. There are 4 methods how a company can become a subsidiary of that. But it is different and very logical. Logical up to million you can go through it from a time. So it says if A company control the board of directors of B company, then B is a subsidiary of A. Right? You can make it a really good for the board of directors are more than 61% shares is the winning, right? The right? If A company controls the board of directors of B company, then B becomes a subsidiary of A. Right? I thought that, if A company receives more than half of the dividend rights of B company, then B is a subsidiary of A. Right? If A company can control the more than 51% of voting rights of B company, then the B company is a subsidiary of A. Right? Because a common dynamic here, if A holds more than 51% share of B company, then the B is a subsidiary of A. Right? ඒක තමයි රිලේට් කරලා අර හතරක් දෙක කියලා නම. right? ඒක එහෙම නොවන වේලාවල් දෙන්නත් පුළුවන් නේ. So therefore there are four methods where a company can become a subsidiary of another company. Right? It's not only the shareholding, right? It may be the voting rights, it may be the controlling rights, it may be the dividend. Right? When one of the control then that company becomes a subsidiary of another. Holding company, I shut the holding company. So good after then, Nandu Gihan comment, then they were over the vehicle industry, right? So with the control voting rights, you get subsidiary. Board day control subsidiary. If it's a fully owned subsidiary, 100% of the fully owned subsidiary, subsidiary control. 100% non-compare, 100% non-compare, exceptions to we discussed that very right. 100% non-compare, directors are taken external from the winners. Yes. You just go to the section 529. Okay. 529 is the interpretation section. Interpretation section again under letter S, it says what is a subsidiary. H, it says what is a holding company. Maybe there. Right. A company is considered a subsidiary of another if and only if that other company either control the corporation of board of directors, right? Able to exercise or control more than half of the maximum number of boards, hold more than half of the issued shares, or is entitled to receive more than half of the every dividend paid. Right? Accountant දැනගන්න ඕන දේවල් නේ. නමුත් කොමන්ලි හැම වෙලේම ලෝයර්ස් වලත් දන්නේ අරගෙන විතරයි. More than 12% shares තියෙනවා subsidiary එකක් කියන්නේ. But these are interpreted by that. Actually කියන එක තමයි subsidiary එකක්. But these all include what you commonly know, eh? 51% vote තියෙනවා කියන එකේ මේ ඔක්කොම ටික තියෙනවා නේ. ඒක තිබුණොත් නේ බෝඩ් එකේ දාන්න 51% vote rights වෙන බෝඩ් එකක් පත් කරන්නේ නේ. dividend rights වෙන්නේ එහෙමනේ. ඒ ඔක්කොම ඒක ඇතුලේ තියෙනවා. හැබැයි ඉතින් ඔය දෙක වෙනස් වෙන්න පුළුවන් නේ. අමරිකාවේ ප්‍රෙසිඩන්ට් පත් කරනවා කියන්නේ. අමරිකාවේ ප්‍රෙසිඩන්ට් තුන කොහොමද පත් කරන්නේ? ඒ මේ ප්‍රෙසිඩන්ට් තුන පත් කරන්නේ රිප්‍රසෙන්ටේටිව්ස් නේ. අපි වගේ කන්ට්‍රි වල ඒගොල්ලෝ ඡන්ද දෙන්නේ ඒ ඉලෙක්ට්‍රෝන එකේ ඉන්න එක්කනේ. අන්තිමට ඒගොල්ලෝ තමයි ගිහලා ඡන්ද දෙන්නේ. ඒක අවස්ථාවක ඒගොල්ලෝ ඡන්ද දෙනවා. විරුද්ධ පක්ෂයේ ඡන්ද දීලා නිරූපිකාව පාස් කරගන්නවා. ඒ වගේ වෙන්න පුළුවන් නේ. පාස වලින් දිවෙනුම් ගිහලා තමයි අන්තිමට ඡන්ද දෙන්නේ. අන්තිමට. ඒක හරි කම්ප්‍රෙස් විදිහට තියෙනවා. ඒක අපිට ඔගේ නෑ නේද? අපි ටයිම් ලිමිට් ඡන්ද දෙනවා කියලා. නමුත් ඒගොල්ලෝ ඡන්ද දෙන්නේ පාස් දෙනවා. අන්තිමට 200 ගානක් කියලා තමයි ඡන්ද දීලා තමයි ප්‍රසිඩන්ට් පත් වෙන්නේ. ඒගොල්ලෝ ඡන්ද දුන්නේ කියලා තමයි ඡන්ද දෙන්නේ. එකපාරක් ඒක එහෙම නෝ. උවන් පැත්ත දුන්නොත් ඒ වගේ අපේ වෙන්නේ ඒ වගේ මේ වගේ එක්ස්ප්ලෝර් දෙන්න බෑ ඩිරෙක්ටර්ස් වරෝනා පැත්ත ගියොත් වෙනස් වෙන පොඩි yes නෑ නෑ Well, so, पालक का अपना होने दिया नहीं right. Apart from that, sometimes also we use the term state company or government company. What is that? Government company or state company. Yes. If all the shares or more than 51% shares of a company belong to the government, we call them government company or state company. SLT board, right? That's an important concept. SLT board is the government on private sector. Board of board. IPN is the government of public company. IPN is the independent election actor limited. Just governed by the government. It's the same company, sometimes known as the public sector company. Public company is known as the public sector state company, right? In those companies, more than 12% of government. But when it comes to the audit and the assess declaration and all, now, what type of companies are subject to assess declaration and auditing and all? Whether private companies are subject to owner. So there are new laws, there's an anti-corruption act, assess declaration laws. Are they applicable to public companies or private companies or what type of company? Audit grant on amount. Are you companies? Private, yeah? Or PLC. PLC is a පුළුවන් මොන එකක් කරන්න පුළුවන් සෝල්වර් එක මම ලෝයි බලන්න ඕනේ and corruption laws assets declaration අදාළ වෙන්නේ මොන වගේ companies වලද government එක විතරයි that's fine government on companies වල දෙන්න තමයි Convince that to be incorporated that we have common. Ito ano private builder company ang wala no. Lagi will going to make a director post natin no. Ito the conflict of interest ay Bible again ang wala. What is that? Incorporate the company and the company act. Right? Hey. Your boss board of directors to his girlfriend. Now a person filed a case for anti-capital laws. Who was even at that? They will want and get again for the given number of that. Private services are more than that. Government के अपना करने वाला है ना नहीं public money का होता है नहीं PSC क्या पास है नहीं Bang itu awal bang kita nak belajar ni lo ni kalau kalau ni auditing and accounting standing act ke तो use करने SBE के special business entities के तो मैं it doesn't matter whether PHC or sole proprietorship right तो बाहर में हम निकालने एक ही डिग्री से तो बाहर आने में turnover के साथ हमारा कितने members सब नहीं ये वाला समावेशन private pro ये turnover वाला करना वाला members लाइन वाला ये वाला ये बड़ा आधा दिन है private के वाले में ये देखा exit करना था आधा दिन है आगे ये private के वाले वो ऐसे काम हम दिन फिर मतलब पास नहीं right ये मतलब आप देखें मैंने क्या है ना वो के वाला आधा दिन नहीं SPE के ना special business activities ना then anti-corruption laws will give to अपना access declaration of cover. Right. Audit करने auditing and standard accounting and auditing standards act के आधार पर audit करने एक दिन use करने SBE के term में एक तमाम anti corruption law का use करता है fine Right. Now we have done the incorporation type of companies and introduction. Then next week, hopefully, we can have a first continuous assessment with those topics. Okay. So online individual quiz.
Hello, sir. Can you update the lecture material to the LMS? This is very helpful. To us.
Yes. So I asked the representative to give me a call. You didn't call me, eh? So you all should say the responsibility, right? Yes. Yes. I will do it today, right? So, right. So as it was not uploaded, I will give you then another week for the online quiz, right? So quiz will be 2 weeks time now, right? Because I have some knowledge, right? So in 2 weeks time, we will have a first continuous assessment, which is online open book test consisting of the first 3 lessons: introduction, incorporation, and the type of constraints. Okay. So then today we can start another topic. Probably we can start. Quiz will be in 2 weeks time. If I upload them today, right? make sure that I get it done tonight. Are you okay with those topics so far on the concept of cooperation, incorporation, company names, and the type of companies? What do you have there? Company names of the If you have any question related to those topics, you can ask me, otherwise we can start a new topic. Shall we go to this new topic or you have a question for what we have spoken? अभी कथा कर दे बात कर रही the topic. If we have any issues, just let me know. Okay. Just during the topic, just let me know. I'm not sure whether you have discussed the company names. It's not a big deal anyway. අල්ලන්නේ කරාද
You guys are very good.
If you want a break, take a break and come.
Asura patul dia, oh yang mau patul dia boleh tidak ikut tidak. Ada yang bilang bukan tidak dia. Ada yang bilang baru begini, ada batu balat kan boleh begini terjadi. Kalau pilih kira pena kan juga kalau pilih itu. Video berapa lah? Kok mati lagi? Mak, kaya? KFC Lanka ada plus. Lokasi apa nanti nih? Ini habis itu kira. Ada yang pasang maksudnya. Ini nak jangan ini. Nah, ini kalau benar. Jadi apa nih? Oh, kita ini lagi deh. Wah, ini tinggal berapa? Lain apa apa kalau saat ini gitu Galle di sana pasar itu ya ada cerita kalau mungkin pari ada ke kepala nggak kepala dia itu apa atau kepala dia itu ada ke kepala ada apa kerja एक बार पता नहीं अभी एक बार कुकिंग में लेते हम ये हो गया और मात्र में तो बाटे पारा की क्या कुछ साधुरा का से कर की ए वो देखो अभी ना ले आइस पैकेट फोड़ने की मामा ना मैं आ इधर आइस पैकेट फोड़ते मामा ऊपर मसाले सब बहुत दूर हर बात है आपका हाँ मामा किया लेक्चर इधर है लेकिन है ada jadi apa? Ambil saja. Bukan. Dia. Ini boleh dia. Tadi di bank yang saya celebrate ni. Umrah ada buku itu ya. Kita saya dah dah tunggu ya. Siapa mana kita? Ada yang tunggu. Apa begini? Ada ya. Ini party ada. हाँ बिरियानी देना फिर आने बेची को तो डेली यार अपने नंबर के नाम को बेची को नहीं पड़ी ये भी किया मैंने ना करे ना अरे ये ना अब ज्यादा रहता है वही ला इस बात में ये बोलने से कोई तो बोलो बस साथ में गाड़ी से बाहर नहीं के साथ में कौन सा ना Pemuda. Bunga lagi tu. Peri pula macam tu dah jangan macam tu. Agak berat dekat. Oh, Julai pun. Register itu lah. Ini kaya apa sebenarnya? Komentar ni pada sini. Yo, like kan? Tapi bayi juga banyak orang yang dia OD juga helmet on ni. Tanya dia थोड़ा बाहर का तो है हेलो हाँ kalau kan mobil kata udah tadi ada mulai kita ini ya kita bagian nih speed kita apa Everybody realize kita belum kerja di mana. Akhirnya tadi. Dan di mana? Orang ini. Kalau dan ini, kita kata well done. Ada gitu nanti ready lah. Iya tak dan sekian dia. Targos itu udah cukup. Ini itu dalam bulan dan bulan. Ini. Bukan itu ya di sini kata.
Norwegian.
Woi, siapa orang kira dia bohong, bohong. Ada gimana? Benar pun. Aduh. Kamu tuh yang kita. Kalau lagi nak pilih. Iya. Happy birthday, Lanka. Iya, वो क्यों ले लेती है वो ले वाला काम बड़ी तरह लूँगे ना ये जमाते हैं तेल पड़ता है अरे इधर एक ही टेबल दे मैं पता है ना एक आदमी नहीं है क्या आदमी की फोटो पर फोटो की एक आदमी jadi benar betul betul kalau kita kalau begini betul ya foto tu dah yang jalan ni foto ini ada apa pite foto tu kan foto macam jadi apa sih foto tu kan angin foto kan lagi tu soalnya kata boleh
Kata
visual model itu kami di nanti ya kan kita harus kita apa boleh
ini dulu berarti apa nanti sama ni bukan ada kiri mari itu jalan 3 menit lagi itu tahu ni Sri kita kalau
ini lagi bah saja itu mama mia tak kita apa
ya beda nama mbak dari tiba apa
ikut itu toh aku beli sehat dah era muda tanah lagi kan kamu muda khas kehatan tahu ya rawatnya dan susah kan kalau kita mana pindah I will read these all speakers. The ball pasal di mana dia tapi oh the ball ka pasal lamai nambe na okay dia kira tapi sama apa itu waktu kita mulai cara pasal ini ya tapi udah boleh di sana kita ada pudi kan sekolah අන්ති මේක තියෙන්නේ මැසරන්ටි වල.
යකෝ ප්‍රයිස් එකකින් ඒව ගන්න නැත්නම් මෙතන ටික. මොකද වැඩට මොකද කියන්නේ? ඔව් මොකද ඔයගොල්ලෝ ෂේ. මොකද උන්ස කොස්ට් කීයද? මොකද මම දැක්කම අපි ඉස්තාව වල නේද? දැන් ඉතින් පාටයිලා බහැනදී ඉවිලන්නේ බා. මේක විකුණලා කියලා තියෙනවා. ඔව්. මොන පොඩි ආර දුරින් නෑකමක් තියනවා කියන ඇටලස් තියෙනවා. ඉතින් පාස් කරලා and තත්පොනි මා
ඕව ඇවිල්ලා 12 C2 කම්පියුටර් C1
මොනිටර් ගාවන්න
අපිට එකපාර වුණත් මේක වාක්‍ය කියලා ඌ ඉස්සරහගේ පිළියන්නේ මංගේ ගණේ
ඌ කැලයි කරලියදී
මම අදී පොළ අදිටියා අපි ආස්තවන්නේ නැහැ පිළිසින කුසල අර තාපයට ඉස්කෝලේ තාපන ඉස්කෝලේ කේමා හරි එහෙම මාළික තමයි තාපෙට ඇත්තේ අපේ ඉස්කෝලේ තාපෙදී කොළඹ තාපය අපි ස්පාඩියේදී පාරයි කරලා පාසලයි කෙල්ලෝ කරපේ පොරොත් කරලා පොරොත් අර මික්ස් Kawuruත් දන්නවනේ ඉස්කෝලේ. ඒ වැඩනේ. ඉස්කෝල තමයි සම්පූර්ණ ගන්නවා ඉස්කෝලේ හොඳයි. ඔගේ ඉස්කෝලේ වගේ නෙමෙයි. Bikin tuh apa deh? Hatta dan tiru nih kalah sih. Itu ya, pero pensar tadi. Galle क्या होता है?
tiga ada.
मैं गाली
तू गाले भी करे.
मटर एक पेमेंट तो पूरा सिनेमा हो गई करते बट विचार कराई करते बट ये क्योंकि एक ही खाता है इसे
Mereka sih sama. Mereka
मतलब आप
होगा मूंगे की डिटेल्स में बात
ऊपर करते हैं यार ये मैं एक बार से तो अपने नीचे को
अरे राज बात है
बना दे बगल बात भी है देखा
साल बाद अरे सीरियस
आईटी को आईटी वाले सेंट्री करेंगे यार पूरा ए लेवल रीजन से यार
ये कला नहीं ना ऐसा नहीं किया तो ये
रिकॉर्ड एक्चुअली होतो साले
अरे कौन सा नाम है
गुरु जानी बात को बोले थी अरे क्रिकेट को है ये लोग आते हैं क्या चला? बात है
क्या हुआ? She's the way that you're giving respect to lecturer. Aduh, sali gitu kan, Mak. Oh iya, I love you. I hate you.
Right. Can we continue? So this is another new topic. Articles of Association. Sanghamika Vyavasthavali is what? Sanghamika Sansthapak, Sanghamika Vyavasthavali. What? Here it is all doing. Before 2007, to incorporate a company, apart from the forms, there were two main documents known as the Memorandum of Association and the Articles of Association. However, from 2007, the requirement of memorandum was done away. Now there's only one document called Articles of Association. Right, so For companies, students, apart from the most important document is the Companies Act. This is the second important document, Articles of Association. Because when directors run companies, so they are only bound to follow and act according to the Companies Act and that. There's no law that directors are bound to follow the instruction or will of the shareholders. But they have to act according to the Companies Act and the Articles of Association. So, yes, after this lesson, you will be, yes, able to identify what is Articles of Association and with special reference to its content. And also, yes, there's principles of beyond the past doctrine of ultra-wireless rules. And also what is meant by the human right role. So basically, we will study the internal and external relationship of the company and the third parties. So these are the subtopics of like, so what are the articles, content of the articles, model articles, effect of articles, articles that is statutory contract, exception for this contract, there is the object clause. Here we will be discussing the section 17 in detail and the issue management code. In any organization, right, whether it's a country or your students association or whatever, there are articles of association, right? So you have a student association. What is it? Oh. What is the association? Sample हो गया ना? Does it have the articles of association? There is just all the people. We have to have how to select that, then how to select that. Second two, how to conduct meetings. Those things must be written somewhere. That document is called articles. Or constitution. Right? The constitution is the benefit. Right? So you read to the benefit is known as the articles of association. A long time ago, it was known as the deed of settlement. Right? Sometimes it was also known as a charter of company, the constitution of the company, articles of association. Right? So there are different terms we use. Nowadays we use it, articles of association. When we discuss about the incorporation of a limited company, we already know that to incorporate a company, you definitely have to have a copy of the articles of association. Right? To incorporate a company, you need to have a Form 1, Form 18, Form 19, and articles of association. So without a copy of the article, you can't incorporate a company. And that first article has to be signed by the initial shareholders. Right? Therefore, this is a must document to incorporate a company. But before 2007, until 2007, even in Sri Lanka, there was a requirement of memorandum of association. Even today in England, India, memorandum is a part of the company law. Memorandum and articles, both are the documents. But in Sri Lanka, we have done it away. This is mainly because of one main reason to introduce this law in 2007 is to simplify the registration process. So when there is a memorandum of articles, basically memorandum control the affairs between company and outside, company and third party. Say as an example, what type of business this company can do. The object clause was a part of the memorandum. What is the stated capital was a part of the memorandum. Therefore, it was considered as the most important documents of the company memorandum because all those information are very important for the third parties, outsiders. Bankers sort of outsiders from capital. So it basically controls the relationship between the company and third parties. Therefore, it was very difficult to amend or alter. And right? However, even though it was such an important document, from 2007 it was done away. Now there's no document called Memorandum of Association. And the article basically control the internal affairs. How to select a director, how to conduct meetings, how to pass resolution, internal matters. Right? Those internal management was controlled by the articles of association, therefore it could be changed. I mean, yes, to change the articles is simple than altering the memorandum. Memorandum is not easy to change because it affects the right of third party. However, that memorandum was now not a party, not a part of the Sri Lankan company, but articles continue to be a part of the Sri Lankan company. Now, one question here is, students now, the object clause was a part of memorandum. Object clause was a part of memorandum. Now there is no memorandum. Therefore, there are some issues where the object clause is a part of Sri Lankan law or not. Object can be memorandum, then memorandum becomes an act. That's all object and the given person. Traditionally, to have object clause was one of the main character of the arbitration person. Because companies are formed to carry out one specific business. They only can do that business and nothing else. Therefore, it was one of the main part of the corporation. Corporation then they only could do that job and nothing else. It is also traditionally considered as one main difference between the natural person and artificial person. Whereas as a natural person, we can do anything unless permitted by law. But as a corporate person, artificial person, they only can do what law permits it to do. All others are permitted. Right? So, if we forget the company law, corporate law, object law, so on, what do you think about having an object clause in company? Is it good to have an object clause or is it good not to have object clause? Memorandum of contract you can normally get it to compare the object clause that we need to handle. And that business investor. They are the investors, you are the business people. As the investors, what do you think? As a business people, what do you think? To have object clause in your business. Below in all nationals. Business മുന്നിൽ കണക്കി സക്സസ് ഒബ്ജക്റ്റ് തീരുമാനത്തിന് പല ഇൻവെസ്റ്റേഴ്സ് കണക്കി campaign objective as seen was the talk to each other. Yes. I'm not talking about I don't not to have an objective at all. My question is whether a company needs to have a specific objective. Would you prefer to have one or would you prefer not to have? What is it? You know, so like that business girl have to be like then okay, talking no chartered accountant. How do you get a chartered accountant here? It's easy can be replaced in the so when a case of objective has to be there. Like objective we have in it. Chartered accountant. It was a house looking, on that. It may have simple so they can work in action. The mobile rate level like all level in the blue objective in mobile rate. When the one is the business element available. The objective has previously would have done a given of the next. If you look at the business mind, I have some doubt about your decision. Why do you want to restrict your business to one or few objects? When you have a freedom not to have. Right? If you have a freedom and all the legal rights not to limit or restrict your business to one or two objects. If you think that you need to restrict this, as a business person, I have a doubt about your thing. As an investor, what is your opinion? One of that, you know, so that time. You know, why? Hey, well, I don't do it so like yes. As the investors, I'm not yes. I can agree with your opinion because you invest. Right? But as a business people, I have some doubt. investors දෙන්න මේකේ දෙයක් තියෙනවා නේ. නැත්තම් මේගොල්ලෝ හිතන්නේ මේගොල්ලෝ මුස්ලිම් මේගොල්ලෝ නම් විදිහේ රෙස්ටොරන්ට් එකේ ඉන්වෙස්ට් කරනවා මුන් ඇවිල්ලා පෝක් විකුණනවා. So, if you don't know the object of the company, you never know what type of business that you have invested. But if a company has an object clause, then the investors can have a clear idea what type of business you have invested in. Therefore, in the investor's point of view, I hope it's maybe a good thing because at least you know where your money goes. Therefore, in the investor's mind, it may be good. At least they know what type of business that they have invested. But when you run business, I think as a business people, your objective must be to maximize the profit more than limited to the object clause. Because nowadays you never know where the business goes next. So, however, we'll see, right? There are plus and minuses in all, but anyway, many developed jurisdiction and in Sri Lanka law also decided that it is not compulsory for the companies to have a object. So it is not compulsory to have object clause for many companies, except guarantee or something like that. Okay, but there's no rule that you can't have one. You can have. It's okay. You can have object clause. No issues at all. That's something. Then you can have object clause and limit your business to that. We are saying, and if it is not something to restrict, but anyway, what law has done, Islamic law have not abolished the object clause, but it has made some flexible rules to run the company without limiting or restricting their business to object clause. That's what law has done. Many people believe in Sri Lanka have done away with the object clause. No. Object is still a part of Sri Lankan company. But it is not restricted to that object clause. Companies are now very similar to human beings. They can do many business just like human. See, as an example, we have already discussed about the candy company. You can't even incorporate a candy company without the object clause. Public companies, when they issue prospectus, they have mentioned the object clause. Any company, when they come to BOI, they have to specify the object clause. All the companies that were registered before 2007 had the object clause. Therefore, object clause is still a part of Sri Lankan law, but it is effect is different to this. So, so in Sri Lanka, until 2007, we had the memorandum and articles. From 2007, the memorandum was done away. However, it doesn't mean that we don't have object clause. We still have articles of association. The object clause now may be within the articles of association. Right? If you want to have object clause, you can incorporate the object clause in the articles of association. So, however, memorandum is completely done away, right? But it doesn't mean that we don't have a object clause. You can have object clause. It may be in the articles of association. Right? So as we don't have two documents as memorandum and articles, the only document except the forms related to complaints is the articles of association. Right? This is also simplified by the companies that giving you a model articles. Right? For a limited companies, there is a model article given by the Schedule 1. income tax, and there are about 15 schedules at the end of the act. The first schedule, model articles. That model articles can be adopted by any limited companies as it is. They are very nicely done. ये सब में किसी हमारे अपने में वादा नहीं हदला करला टाइप पे डील up to when you want to incorporate a company, what you want to do is to retype them and sign at the end. Write your company name at the top. That's it, right? So it's very nice drafted. Then, yes, when you incorporate a company, we have a option to adopt the model archive. And also, these model archives are anyway only for the limited companies. For the guarantee company, we know you have to have a object clause. Therefore, no one can draft articles for the guarantee companies. For the guarantee companies, we have to adapt your own articles. Therefore, when you incorporate company, now you have two options. One is to have to adapt the model articles or to have a fresh articles of association. Right. So basically, whenever we discuss about the rights, duties, powers of the company, we always use the term subject to articles, right? Because it is the articles of association which set out the rights, duties, liabilities of shareholders and the directors. What company can do, what company cannot. What's the objective? How to sign the resolution, how to pass the resolution, right? Everything is mentioned. Therefore, whenever we do something, right, we write them subject to the articles, right? So, even section 2 says that the company can undertake any business or activity to do any act or entry to any transaction. Then we use the term subject to articles because there may be some restriction imposed by the articles. Section 13 says what should be included in the articles of association. What could be included in the articles of association? So it says articles of association, among others, may include the object of the company. So that is why I said, like, object clause is still a part of Srilankan law, but I use the term may. Okay. May include object clause. If it is compulsory, Act use the term shall. Limited company Act again shall include may include that is section 13. Therefore, it is optional. Or none that pulwa, or none that that pulwa. Limited company incorporate current or not. Object clause that pulwa or not that pulwa. Many cases shall use that. So, articles may provide for object of the company, rights and obligation of shareholders, and the management and administration of the company. Accordingly, yes. You also can have a look of first schedule. First schedule, what could be included in the articles of association. So these are basically part of the articles. The limited liability of members, right of shareholders and guarantors, right? How decisions are made, what are the type of resolution they can pass, how to pass resolution, right? The responsibilities and powers of company and directors, right? So basically they include object, that is what it can do, what it cannot do, right? And the rights and liabilities of shareholders and the directors and the management of the company, right? how to hire a director, how to appoint director, how to remove director, right? How to issue shares, how to decide consideration, how to issue dividends. So all those internal matters, right? The procedure is set out in the Articles of Association. And also companies have a right to amend articles, right? Articles can be amended or altered at any time, but only according to the Companies Act. So, shareholders cannot ask directors how to act, but they can alter the articles. Then the directors are bound to act according to the Articles of Association. So, Articles of Association can be altered or amended by the shareholders by passing a special resolution. It can't be done by the board. It can't be done by the simple majority. Right? So to amend the articles can be amended, but for that, more than 75% of shareholders must act. 75%. Directors are taken as the simple majority taken, but if more than 75% of shareholders agree, then the companies can amend its articles. Basically, yes, Articles of Association is like a contract. Yes, any company may alter, modify its Articles of Association by passing special resolution. Special resolution. And also it is a right of the shareholder to request the copy of the Articles of Association. It is a statutory right. No company can deny it. And companies, when there is such a request from the shareholder, companies are bound to provide it within 5 working days. If the model articles can be adopted as it is, Articles of Association is like a contract. Articles of Association is like a contract. Once it is signed, passed by the approved, then it is a contract. It is a contract like, in one hand, it is a contract between company and shareholders. And also it is a contract between shareholders and shareholders. Therefore, if one party breach or break his part, then the other party can file a case and get damage. So therefore, that is the effect of Articles of Association. Articles of Association is act as a contract between shareholders and shareholders, and also it is a contract between company and shareholders. At the same time, we already know that company is a separate person. Shareholders, directors are separate persons. Therefore, they all can enter into contract with the company. Maybe supply contract, service contract, employment contract. CEO, managing director, company contract and input. So it is also contract. Articles is also a contract. So the difference between these two, shareholders or directors or company may have number of contracts like supply contract, employment contract, finance contract, trading contract, and Articles of Association is also considered as a contract between company and shareholders. The difference between these different two types of contract is that Articles of Association is a statutory contract. It is vyavastha. Therefore, if there is any issue about the Articles of Association, then it is settled according to the principles of company, not according to the principles of contract. But all other individual contracts, employment contract, supply contract, whatever, when there are issues or disputes, they are decided according to the principles of contract. But any dispute related to the articles of association is considered and settled according to the principles of contract. That's the difference because it is a statutory contract. But this is one example. In this case, according to the articles of association of a company, before payment of any dividends, it has to be approved by the shareholders' resolution. Shareholders have to approve. In one occasion, the company has declared dividends, but it is not approved by the shareholders' resolution. So therefore, one shareholder challenges. But court decided as articles provide that it has to be approved by the shareholders meeting. If it is not, then it is against the law. Because law says before payment of dividend, according to the articles, it is to be approved by the articles, approved by the resolution passed by the shareholders. Because it's a contract, then they have to act accordingly. There was another case. In that case, it's not here. I explained the case. In this case, there was a company's articles. According to the articles, it said if there is any dispute, first they have to be referred to the arbitration. According to the articles, if there is any dispute between company and the shareholders, then first it should be referred to the arbitration. That's what the article said. At one time, there was a difference between the company and one shareholder. This shareholder, without going to arbitration, directly filed a case before the court. Then the company argued that this is a breach of contract. According to the articles of association, first it has to be referred to the arbitration. So court accepted. Court accepted. If article provides that first you have to refer it to the arbitration, then it is a contract, you are bound by that article. Then this is a breach of contract, and then court did not accept that case. Court ordered the parties to go to the arbitration. Because when there is a law in the articles, you have to follow it because it's a contract. But in another case, in this case, court decided it is a contract only as a capacity of member, not in any other capacity. In this case, the articles provided that all the company litigation must be given to the company lawyer. Sorry. In one situation, company sent its cases litigation to outside law. Then the company solicitor filed a case according to articles they should be given to her. In this case, court decided no, it is not a breach of contract because here litigations should send to the solicitor not as a member but as a lawyer. Articles is only for the member. Right? So here litigation should be taken by the solicitor not as a member. Members are not what? This as a capacity of a lawyer. Therefore, it is not a contract in any other capacity. It is a contract only as a capacity of a member of the company, right? Therefore, it is a contract but only as a capacity of the member, not in any other capacity. So, simply my articles of association is a contract between company and shareholders, and also between shareholders and shareholders as the capacity of a member. Basically, if there's a contract, then all parties are bound by that contract. But in law, there are no rigid rules. There are exceptions for any strict rules in law. So these are the exceptions for the articles of association. Even though articles is a contract between company and shareholders, then if it's a contract, then they are bound by that articles. However, Section 89 says, notwithstanding anything to the contrary in the articles of the company, shareholders are not liable, should not be bound by a resolution altering its articles or required to acquire or hold more shares in the company. If article is a contract, then it's a contract, they are bound by that term. Right? But Section 89 says, if article amended, then shareholders are not liable by that amended articles. Or if articles amended to increase the liability, then again shareholders are not liable if they have not voted in favor of that amendment. It simply says, no one can increase the liability of shareholders. Liable if they have voted in favor of that article. Because no one can increase the liability of another without their consent. It's a outside shares shares very liable liable amendment in favor of vote. Therefore, this is clearly in line with the legal principles. No one can increase the liability of member without their written consent. If so, it is not a contract. This is an exception. Therefore, basically, article is a contract, but if company change, alter its articles, then the shareholders are not liable by that amended articles if it increase their liability. Right? Hi, Krishna, we will continue this lesson next week. So, I will give me a call. You have my number. Yes, sir. Give me a call tonight or tomorrow night if I will upload the slide. You take 18 minutes. Maybe Richard.
Yeah. Semester six.
So can you share the screen?
Hello, sir. Can you share the attendance?
Sir, can you share the screen?
ඔගොල්ලෝ කොහොම කරානේ?
Oh,